Yeah, I know.
Hi, everyone. Thank you so much for joining us today. I am Silvia Marchilli. I'm a partner here in Miami Arbitration team by the case. And I'm also wearing today my MIA hat as the chair this year. One of the things that we've been alluding to lately at MIA is the wonderful growth of Miami as truly a global hub for international arbitration. And what better testament to that being at the forefront of leadership in our field. And we are at the forefront of thought leadership in our practice because of the cases that we handle from our Miami office, like many of our colleagues here in the room. We do so also by organizing events, by being active members of the arbitration community, as we like to describe ourselves, whether it's at the club meeting or otherwise. We partner with of course, and their wonderful programs, and I'm looking here at that, of course. And we also benefit from events like today, the lecture that we're going to hear today, from none other than Professor Bourne. And we just experienced the growth of Miami and how solid of a community we are, because just by dropping, Bourne's name, you have a sold out event, and we have our contacts actually trying to get in. That's fantastic. And it's tough when you have to introduce someone like Professor Bourne, because I could just spend the entire time going through his bio. But I'll say three things. One, obvious one, which is he's the chair of the International Arbitration Team with Marchilli. The second is that I am old enough to remember when there were just a handful of books out there on international arbitration. And as we were trying to figure out which arguments to make, what was the law out there, what we could or could not argue, there was little light. It was just perhaps a bookshelf of some publications and a few articles. But one of the most helpful tools that I found as I was trying to figure out what I could or could not say in a brief, even if it was a commercial case or an investor state case, it was Gary Bourne's book, International Commercial Arbitration, and the wonderful footnotes that will point us to the right path of making a remotely reasonable argument, again, from the practice and the general knowledge. And he's also the author, third, of the file. And the file is not part of a reference schedule or a document production or a case yet, maybe, but a thriller that has been critically acclaimed, and I encourage all of you to read. And the cover is quite interesting and a bit different from the International Commercial Arbitration book, if I can say that. And I thought of one of the critics put it the right way. A globe-trotting thriller as American and Russian intelligence operatives race to hunt down the discoverer of a long-buried secret told with eloquence and ruthless efficiency. And of course, it's a book by Professor Bourne, so eloquence was the word that had to be there. And with that, Professor Bourne, the voice is
Thank you so much for that hopefully kind product introduction and for the product space. Policy very outset. Let me also thank others, in particular the University of Miami Law School, where Alicia State hosted. Again, for the third year as well. Thanks also to White Case, a great law firm that has used tremendous lawyers as well. And I very much appreciate thanks also to yes, force in international arbitration. Most importantly, of course, thank you. Miami's a great place during the day and evenings. Today, this evening is going to be, I think, a little bit different. You know, you're in that shape when the person introduces you by reference to your footnotes. Is that really what you want to go down in life as having footnotes? So you have to have a file, but still. Unfortunately, while we're in the footnote mode, today's lecture is a little bit footnote. Today's lecture isn't really a lecture. It's instead like one of those movies that has sort of vignettes, episodes involving different people or different things. And I sort of stole stuff. I hope it's going to lead to some kind of copyright. I stole things from some applications somehow. But what I want to do is go through some footnotes, or things like footnotes, some international arbitration developments over the last. I did it last year, but it's going to be more than just a year. And what I want to do is try to go through these, both give a little bit of context to each one of them, and also to decide whether we should swipe left, which means we don't like it, which is something like that, or alternatively swipe right. This is a positive development for international arbitration for the rule of law. And this is the one effort to save my life with a little bit of humor. So let's begin. This is going to be a whirlwind tour. If you have questions, perhaps say to the end, because things moving along quickly. And what I'll do is just say a few sentences about each one of these things. This is an English UK Supreme Court decision, a wonderfully titled decision about Marchilli versus Health Food Group. The reason that it's important is that the UK Supreme Court refused to enforce an ICC arbitration award made in Paris and brought to the UK for recognition under the New York Convention. And the issue was whether a non-signatory was bound by the arbitration agreement, which in turn required deciding what law applied to the arbitration agreement. The English court, picking up in this case on an earlier decision by the UK Supreme Court, in a case called Inca versus Chubb, held that if you have a choice of law clause in the underlying contract, that choice of law clause also selects the law governing the arbitration agreement. In this particular case, there was a choice of law clause selecting English law. The English court therefore applied English law to the arbitration agreement and concluded that the non-signatory was properly bound by either the arbitration agreement or the arbitral award. I would suggest on this one, this slide, but I would suggest on this one, swipe left, bad. The reason it's bad is that, and of course, people really disagree with me, my treatise, the one with all the footnotes, often disagrees with itself. It said that you can find support for almost any proposition in that. And also, this support the opposite of that proposition. So if you disagree with me on whether we should swipe left on the principle, a general choice of law clause in the underlying commercial contract selects the law governing the arbitration agreement, so be it. I think that's a bad decision. Not only do I think that, the French Court of Cassation also thinks exactly the same thing. Consistent with French law generally, the French Supreme Court concluded that the arbitration agreement is independent, separable from the underlying contract. That's a rule that is fairly familiar here, as well as most other places in the world. And that, as a matter of French law, the law of the sea, France, which is, from French perspective, applying international arbitration law, was applicable to the arbitration agreement and to the question of whether or not signatory bound reached the opposite conclusion from the English court. Swipe right. The arbitration agreement is separable and independent from the underlying contract. If you have a choice between the law of the arbitral sea on the one hand and the law selected to govern the underlying contract on the other hand, the vastly superior choice is the law of the arbitral sea. It has much more to do with the arbitration agreement, with the arbitral process, than the law governing the underlying contract. Swipe right. The reason I say swipe right is that the Law Commission in the United Kingdom, reflecting on the Marchilli and versus Chubb cases, reached the conclusion that I had just described, reached the conclusion that unless otherwise explicitly provided by the parties, parties could be free to select a particular law arbitration agreement. They were free to do so, but unless they have done so specifically with respect to the arbitration agreement, the default rule is the arbitration agreement should be governed by the law of the arbitral sea. So it's not just recommendation 19 of the UK Law Commission, it is also now in the Parliament Kingdom, where in all likelihood the English Arbitration Act of 1996 would be amended to provide exactly this, as I said. Right. This is an interesting subject case. Footnotes. These are from the Indian Supreme Court. Let's start by swiping right. Why should we swipe right? We swipe right because a three-judge panel of the Indian Supreme Court, those of you who are judiciary will know that the Supreme Court sits by panels. It's not like panels. This was a three-judge panel which considered the question of whether an arbitration agreement in an unstamped contract was valid, even though the underlying unstamped contract was invalid. Is the arbitration agreement in those circumstances where the underlying contract is invalid, valid, or invalid? Three-judge panel said arbitration agreement is subject to agreement autonomous. The underlying contract, the underlying contract is void, invalid, is irrelevant. The arbitration agreement is an independent, invalid contract. That arbitral tribunal can consider claims that the underlying contract is invalid. A little bit like in this country that you're going to make a decision on which contract or the Buckeye Chubb cash. Supreme Court. Swipe left, because shortly after that happened, a five-judge bench of the Indian Supreme Court reached the opposite conclusion. They reached the conclusion that the underlying contract is invalid in the arbitration provision of 5 and 7 articles. Understand the contract also is invalid. The contract is in error. Arbitration is right. Swipe left. Does that really undermines the efficacy of the arbitral process? Don't worry, the world ends well, because a 7-judge panel will not be a 9-judge panel. A 7-judge panel of the Indian Supreme Court goes back to where things began, right? Concluding that the invalidity of the underlying contract, including because it was unstamped, as Indian law requires contracts to stamp, it did affect the validity of the arbitration clause included in that contract. As I say, it's like right. Interesting case. I'm not unsure whether we should swipe right or left. It's perhaps right and a half ambivalence. It's interesting though. Louisiana, District Court of Louisiana, this country, considers the following circumstance. Parties agreed to arbitrate before what was a well-recognized arbitral institution in the Middle East. The DISC/LCIA, arbitral institution, which was the joint venture between the Dubai International Financial Center and offshore jurisdiction and the London Court of International Arbitration. That a well-developed, well-functioning arbitral institution until a couple of years ago, out of the blue, the Dubai shuttered the DISC/LCIA and by decree replaced it with the DIAC, rather similar in the rules that it had, but a different governing body, individuals, and also rules. What happens in those circumstances to contracts many already provide for arbitration under the DISC/LCIA rules? The party that wanted to arbitrate before the DISC relied upon the Dubai decree. It said, more or less, DISC/LCIA means DIAC. All of the functions exercised by the DISC/LCIA now belong to the DIAC. Is that, therefore, now an arbitration clause requiring the parties to arbitrate before DIAC? District Court says no. See the language on the slide. I won't read it out, but according to the District Court, you're required to arbitrate in accordance with the parties of arbitration. Consent. Based on consent. Parties didn't consent to arbitrate for the DIAC. Therefore, no order of arbitration and litigation. Court's jurisdiction initiated there in Louisiana, without litigation and go forward. On balance, I'd say swipe right. Parties agreed to arbitrate before particular institutions. They make informed considered choices about that, where there is a significant overnight change to the institution being replaced by a different institution. The better view I would suggest is the parties ought not be required to arbitrate for that institution. I think an open question presented to the court would be, is there still some sort of valid arbitration? Does the fact that the institution, pursuant to rules they agreed to arbitrate, no longer exists, does that issue their agreement to arbitrate? Could one, for example, have an ad hoc arbitration in those circumstances? I think that's a difficult question, and without having argument by the parties in that case, I'll reserve judgment. I'll swipe right, swipe left. But I think swiping right on the decision you don't have to arbitrate when the rule says you have to arbitrate, it's probably the right result. Whether you have to arbitrate somewhere else, it's a question. Next question. Back to India, group of companies. This is, we're thinking about the parties engaged in cross-border transactions with companies. The group of companies theory goes back, like many good things, to France. There, in an ICC arbitral award titled Dow Chemicals, an arbitral tribunal, distinguished arbitral tribunal, concluded that there was a doctrine heard of in or outside the arbitration field called group of companies theory. What does that mean? It means that if company A, or companies, signs a contract arbitration agreement with the counterparty, in some circumstances, company A's affiliate B.
So that folks can hear you a little bit better. This. Sorry.
Shall I start over? We're not enough enthusiasm on that one. So under this group of companies theory, companies B, C, and D who didn't sign the arbitration agreement and who aren't alter egos or agents or other things that would permit ordinarily a non-signatory bound by the arbitration agreement. Nonetheless, by virtue of its doctrine, can be bound by the arbitration agreement. It doesn't affect the underlying contract, but where parties, companies are members of a group of companies and have certain connections with the underlying contract, participate in negotiation, participate in the performance of the contract, they can be bound by the arbitration agreement in that contract. Maybe swipe left, maybe swipe right, I'm not sure. History's judgment of that award and the group of companies doctrine was decidedly swipe left. The English Supreme Court famously said English law does not know companies doctrine. Swiss courts said pretty much the same thing. Courts in other jurisdictions and many commentators have agreed with that view, which they all said swipe left. Indian Supreme Court, adopted the group of companies here. You can see the requirements they impose. They treat it as a matter of intent, but they focus on intent to be bound by the arbitration agreement and objective considerations as to the parties' imputed desire to have a functioning resolution mechanism. According to the Indian Supreme Court, that means a little bit like that ICC award in the Dow Chemical case, companies that are non-signatory nonetheless be bound as part of a group of companies by an arbitration agreement if they have something to do with the underlying transaction. For US companies, American companies, other companies outside of India, this is something to be mindful of because it suggests that the generally will uphold decisions that extend arbitration agreements to non-signatories. Swipe right or swipe left. In general, I tend to, and I suspect that things on the most swipe with me. I want to swipe right on this one. I think parties litigating outside the arbitration process and that the dispute resolved somewhat other than where their affiliates agree to have the dispute resolved represent a considerable threat to the arbitration process and therefore expanding the scope of the arbitration agreement, but not necessarily the obligations of the underlying contract is a good thing, but I understand most or all of you want to swipe that. Yeah. This is a series of slides. It raises, I think, interesting conceptual issues and also ones that have much more application than many of us would think. Casey will explain it. Let's start because it's 2 or 3 slides and different decisions in different jurisdictions with Noble Resources versus Shanghai. Decision by a Shanghai appellate court. And the action in China was an application to recognize an award made by a sole arbitrator seated in Singapore under the Singapore International Arbitration Center's rules for expedited arbitration. Under those rules, if you have a small value dispute, less than $2 million, the arbitration rules provided that the arbitral institution had the authority to refer the dispute to the sole arbitrator and to put it on a fast track procedure, meaning that the sole arbitrator was required, absent exceptional circumstances, and permission from the institution to make an award within 6 months. The reason for this expedited procedure provision in the SIC rules was to meet the criticisms of the arbitral process that it takes too long, it's too expensive. That's why you have a sole arbitrator. Step 3. That's why you have a 6-month timetable. Money in the arbitral process is elsewhere. And incidentally, having a sole arbitrator is pretty much what is necessary to get a 6-month timetable. The arbitrator to make sure all the diaries coincide with a 6-month period. Sole arbitrator makes an award and takes it to China. You must be wondering, well, what could be wrong with all that? What was wrong with all that was the parties' arbitration also provided that it was resolved by 3 arbitrators. And what was presented with and accepted the argument. One. And on some level, one might think that decision is correct. It doesn't. But I don't think that's right. Swipe left. The reason for the swipe left is as follows. We swipe left because the parties' agreement wasn't just an arbitration. Instead, there was we're going to arbitrate from 3 arbitrators under the SI's contracts 101. We give effect to all the terms of the parties' contract including arbitration. Those terms said that even if you agreed to arbitrate in front of 3 arbitrators as a general matter, in a specific set of cases, i.e. small business disputes for the institution fast tracks it, your choice of 3 can be changed to a choice of 1. Parties of agreement recognize the possibility that this type of case would be a sole arbitrator. As, if I can put it this way, as a de novo question of contract interpretation, I think that's right. I think what I just said is right, and that what the Chinese court said is wrong. But important. We don't really, in those cases, if you think about it, approach it as a de novo question of contract. We instead should approach it as a question of whether the arbitral institution in this case properly exercised its procedural discretion in administering the arbitration and its own rules. SIC had interpreted its own rules to permit exactly what was done in this case. The Singaporean courts, as being an arbitration seat in Singapore, had upheld those interpretations. And I would suggest that when it comes to a recognition proceeding, it is very important to give appropriate deference to the procedural determinations. That's what this was of both the arbitral institution and the courts of arbitration, as well as, when we come to it, an arbitral tribunal similar procedural decisions. Therefore, on that case, it was looked at swipe left. What about this case? This is Singapore. This says some nice things about long, close, affectionate relationship with Singapore as the president of the Singapore International Arbitration Center. But in this case, the Singapore Court of Appeal, their highest court, I think got it wrong, swipe left. What did they do? For swipe left. They held that an arbitration agreement that was, without any conceivable doubt, poorly ambiguous, properly interpreted, provided for a different seat of arbitration than that which the arbitral tribunal has selected. The arbitration agreement provided for arbitration before a well-recognized arbitral institution in Macau. That's what the clause said. As the Court of Appeals, Singapore Court of Appeals said, that is ambiguous, both with respect to whatever arbitral institution is choosing and with respect to the arbitral state. In a default arbitration, where the claimant had initially said, let's see this in Macau. The arbitral tribunal said, actually, we shouldn't see this in Macau. We think the proper interpretation of the law governing the underlying contract in Singapore law, we think the proper secret would be Singapore. The claimant in that case, the default proceeding, accepted that. So the case went forward in the default proceeding, seated in Singapore instead of Macau. The Singapore Court of Appeal, after lengthy proceedings, decided 2 things. It decided, first of all, the arbitration hadn't been conducted in accordance with the parties' agreement, because in its view, a proper interpretation of the clause was that the arbitration should have been seated in Macau, not in Singapore. look at this as a question of de novo contract construction. Maybe they're right, maybe they're wrong. Who really knows what that clause means? Importantly, though, this shouldn't be a de novo question of contract interpretation. Where you have an ambiguous provision, the arbitral tribunal ought to have the authority to interpret that clause and its interpretation to say where it's blatantly wrong. What to be given like that. Therefore, what left on the Singapore Court of Appeals insistence on imposing its own contract interpretation on the arbitration agreement, which is it. Second thing the Singapore Court did was, when you make such a fundamental mistake as to seek the arbitration in the wrong place, you don't need to show any prejudice or injurious effects as a consequence of that. Therefore, automatically required to recognize this award, irrespective of any showing as to how the arbitration might be conducted differently or things might be the proper of how. Again, I respect that. Where a procedural misstep occurs, there ought to be some side either in the recognition proceedings and award. There ought to be a required of prejudice. Let's swipe right this one though. Back to this country, the United States. There are in fact a substantial number of decisions that do pretty much what this Court of Appeals held. It held that questions of arbitral venue, even those arising in international arbitration, are presumptively for the arbitrator to decide. That, incidentally, applied in the Singapore case that we just looked at, would have upheld the tribunal's interpretation of the ambiguous reference to virtue and arbitral seat. In this particular case, there was an arbitration agreement that provided that claims would be brought in the respondent's home state, selected, as some clauses perhaps unwisely do, a kind of floating seat of arbitration, depending on who was a claimant who was the respondent. That probably doesn't make sense in the first instance, but where it particularly creates problems, as it did in this case, what do you do if there's a counterclaim? I forget exactly which side of the debate the tribunal was or wasn't in this particular case, but more fundamentally, it shouldn't really matter because the arbitral tribunal ought to have the authority to interpret clauses like that to regulate procedure in those cases. That's what the Court of Appeal did. Swipe right. Had its reasoning then followed by either the Shanghai Court or the Singapore Court, they would reach the opposite results. Good things. Right. Again, slightly different. We've got lots of Venezuelans in the audience, just at that moment. This was, and they probably know this case better than I do, Northrop Grumman versus the Venezuelan Ministry of Defense. The arbitral tribunal moved the arbitral seat. It was specified as Venezuela, but given extraordinary changes in the climate and other circumstances in Venezuela, the tribunal said we're going to move this to somewhere else in order to safeguard the neutrality and integrity of the arbitration. The U.S. Court of Appeals needed to consider whether that was a proper exercise of the tribunal's authority. He said it was. Swipe right or swipe left. This is a little, and this is, I think, the tough one. You have an unambiguous agreement, not an agreement that requires interpretation, unambiguous agreement. And the tribunal override that contractual choice. There are contractual documents, or doctrines that let you do that. Take circumstances, possibility. There's also, of course, the possibility of denying recognition and an award. If the tribunal exercises its authority under those doctrines, should that exercise give effect? Should it deference? I think where you don't have a tribunal exercising its power to interpret ambiguous or simply exercising procedural discretion that would have in the absence of any agreement by the parties, and is instead confronted with express agreement by the parties, one collides with the basic principle of arbitration is a creature of the same. The parties consent to something, even if it's something that turns out to be a bad deal for one party. Legal contract, contractual autonomy, is guiding force in arbitration. It would take a creeping extraordinary show querying whether such a change, no matter how bad the conditions were, had actually occurred. I'm not this is a case that I'm sure some many are familiar with.
This is a swipe right.
Yeah. I knew it. There may be someone else in here who wants to swipe left.
I have a vote.
Let's fly.
Because well, I argued it. So, but I think it was the right result. It's up in front of the U.S. Supreme Court now, but I think the tribunal got it right. The ICC looked at it and decided that it was not an issue. And but in any event, there certainly was no evidence to support evident partiality because there was no interest of the parties. In most of the cases that looked at evident partiality, there's been some connection to the parties themselves. This was just counsel, and I think the 11th Circuit got it right. Judge Marcus's decision very clearly says that there was nothing here showing that these were not just anything other than professional contacts that are expected. So that's my position.
Anybody want to swipe left? Well, maybe I can tell you about the case. Many of you may know it, and if I mishandle it, apologies. I ought to know about it. ICC tribunal, distinguished ICC tribunal, lengthy arbitration here in Miami, issued multiple partial awards. See the dollar figures on the slide. After one of the partial awards in favor of ACP, now authority against this, I'm not sure what's for that. It moved to vacate the award here on the basis that the arbitral tribunal had acted with evident partiality, which no is the grounds for vacature under the Federal Arbitration Act. Basis for the evident partiality claim was that the arbitrators had been challenged after the partial award was made in the ICC, and that the ICC had concluded, at least with respect to certain things for certain of the arbitrators, that there had been a non-disclosure of things that should have been disclosed. The ICC importantly also went on, however, to, as suggested, to deny the application to remove the arbitrators, and the arbitration therefore continued with those same arbitrators. The argument in the district court and subsequently the Court of Appeal was that the arbitrators had not complied with the arbitration procedures. If it were under the New York Convention, effectively in Article 5D, objection, the arbitration was conducted in accordance with the procedure by the parties. And the theory was the ICC rules required the arbitrators to disclose certain things. The ICC did what the arbitrators didn't, so they should disclose additional stuff, which they hadn't. Therefore, the arbitration hadn't been conducted in accordance with the ICC arbitration rules. The Court of Appeal, like this court, rejected that one. They concluded that the non-disclosures were not particularly significant. The arbitrators failed to disclose the fact that, and yeah, I don't say much about this, done arbitration that didn't require disclosure of the fact that these tribunal members with unrelated cases sat on tribunals together or they involved. The Court of Appeals decided it's inevitable in a world like international arbitration that there were mentions of that sort. And it should have been disclosed, shouldn't have been disclosed, little tough messages. Says they should have had to say that they need to be. But ultimately, this was not a sufficient basis for evident partiality. And evident partiality is a significant requirement, significantly higher to vacate an award that is required for either disclosure or removal of an arbitrator from the institution. Check the application, remove the arbitrators, they follow their award. Day that could set aside. I do think, although this might mention previously in this case, which I stand entirely behind, sway right or reach the right conclusion, in my view. But others disagree, and it's for the certain. You can come back to that, man. Anything else? Just to take the opposite view, arbitrator partiality, lack of partiality and independence. ICC award made by a leading French arbitrator, set aside by the Paris Court of Appeals, set aside because he, the arbitrator, had written a eulogy for Emmanuel Gaillard, a recognized partner of first year who was lead counsel in the case before the arbitrator. Among other things, the arbitrator said that he never made a decision without consulting Professor Gaillard. So a little bit awkward to say that when the arbitrator probably on this one quite right. I think that challenges to arbitrators and the scope of disclosure has gone too far. The pendulum should swing back. On that proposal, but that's what I think. Even if you don't accept that, though, or if you do accept it, this would probably be a annulment. Certainly, removal of an arbitrator would be appropriate. So I said that this is going to be a boring lecture. We're going to talk about a bunch of footnote cases because it's sort of hard to talk about the last couple of years in international arbitration and national cases. So I'll try to talk about something other than cases to show you that I'm a real person. The rise of regional institutions, regional arbitration centers. The ICC is still the top dog. You can see on the top graph, 57% of respondents. I think this was a white case study, actually. And Queen Mary, yes, this is 2021. Favored institutions. Who do people like as an institution? Who do people like you choose as your favorite institution? ICC still at 57, but it's fairly extraordinary here in terms of what kind of support other institutions attract. SIC, 49%, only 8 percentage points below ICC. HKIC, this one really boggles the mind. What's happened in Hong Kong, it's like that. 44%. What would it be if we held it today? Maybe not that. CTAC, China International Trade Arbitration Commission, 17%. Probably trending down also. LCIA, 39%. Maybe that's around where it belongs. What do I think? I think there's been a flight to quality. There has certainly been a rise of regional arbitration centers. We'll look at that in just a moment on the next slide. But my instinct watching businesses, particularly in the light of things like the IFC, LCIA, well-recognized arbitration institution, relatively new jurisdiction, is shuttered overnight. I think that makes in-house counsel, makes external advisors hesitant about experimenting. Obviously, they've always been hesitant. You want to choose a tried and true, well-experienced institution. But in my view, there has been a tendency to prefer really well-known, really well-qualified institutions as opposed to trying out new stuff. That's counterbalanced by the fact, and this is a statistic that actually really caught my attention. It's counterbalanced by the fact that jurisdictions around the world are strongly pushing through their state-owned enterprises local arbitral institutions. One can see that in the Middle East. One can see it's important yearly, but that's part of the game plan. The statistic that really opened my eyes was the ICC reporting about ICC arbitrations in the last couple of years. Said that 20% of all ICC arbitrations involved on one side or the other a state-related party. The reason that's important is that, and that is double what it was a decade ago. What that means to me as a dispute resolution lawyer is state-owned enterprises are playing a much more role. And you got to put that together with the fact that states have a vested interest in the dispute resolution process, in particular in their own jurisdictions. And what they do is insist with counterparties on seating the arbitration locally or arbitration is ultimately a creature of consent. I said before that you live by it, and that will undoubtedly continue to be the rule. But the rising importance of state-owned entities in international disputes, coupled with the availability of state-sponsored institutions, is an issue. I'm not sure it's winter coming, but the train's like right. Yeah.
That brings me back to, excuse me, to the Venezuela case you were discussing. I'm curious because you said the clause was unambiguous, made the court decisions more difficult, obviously. You recall that clause used the word seating the arbitration versus it shall be held in, or something more vague where you can have it seated in country A and country B.
I do not. It is quite important as we're drafting now to have regard to the fact that place for seat of arbitration is from the heart. It's a place that it's definitely a place, right? It's not a geographical location. It is a choice of law. It is a place under whose arbitration law the arbitration will be conducted, and critically where in the annulment vacate your application can be made. Maybe something to talk about the place where hearings will be held. That is a geographical location. It doesn't vary the choice of law implications that choice of the seat does. Swipe left, Gary, because I don't know the answer to your question. What I do know the answer to this is something that's in thinking about this slide, trying to show you how to do it first, I wanted I wanted to look at sort of what is the rise of these regional institutions and relatedly sort of regional seats, which means seats other than the places that were originally back in the day typically chosen for arbitral seats. I apologize because this is pretty hard to read, but let me help you. There are 3 columns, 2000, 2010, 2001. Each column contains countries arranged by colors. The colors are all in the same order in each of the 3 years. They start on the far left with Switzerland, they then move to France, and then UK, then to the US, followed by and this is sort of interesting. In 2000, Switzerland led the act, 84 cases. France close second, 79. UK, 55. United States, 43. Germany, 20. How does the world change in 2010? Switzerland hasn't changed. It's gone from 84 to 86. France has upped its game from effectively 80 to 124. The UK has somewhat upped its game, 55 to 70. The US hasn't done much, stuck at 44. Germany at 27. You're beginning there to see some new entrants. There's Mexico and there's Hong Kong on the far right, in the middle column. And Hong Kong significant in itself versus 2000. The interesting thing, I think, though, is then to look at the next one. Switzerland has moved up to 104. France has gone back to where it started at 88. The UK has continued its steady increase. So starting out at 55, going to 70, it's now at 85. We guys, Go Team America, are at 88, which, if you compare to 2000, which was 43, we basically doubled our numbers, which compared to what the French and the Swiss have done, even what the English have done, is a pretty extraordinary step. The poor Germans, if you look at them, they're at 16, which is compared to 23 that they had. Sorry, compared to what they had back in 2000. And the Brazilians, where are all the Brazilians that I've met in coffee hour? There. Look at you guys. 30. And some other entrants here. UAE, making an increasingly strong showing, perhaps. And this is only ICC cases. This doesn't have the ICA stuff. Which nonetheless ought to be fairly representative of cases generally, but putting aside the local institutions where there would be a strong bias, not a local institution that we see, but also a slightly different visual presentation of this on this slide. But what I think both these slides do is show a couple of things. First, I think it shows perhaps not so much the rise of regional centers, but a decline of the whole guard. France and Switzerland certainly have an increased absolute numbers. In terms of a portion of the total number of arbitration cases, they absolutely increased. And that has been more than in the case of France than Switzerland. Some older jurisdictions, Turkey, Austria, have continued to decline. You've seen the rise of some new jurisdictions, Brazil most obviously, but also Singapore and UAE. How what I predicted about flight to quality will affect all this, I don't know. But it is a more diverse and somewhat more complicated world than it used to be. Everybody's starting to get restless. We can stop. But I'm almost done. The arbitrators before have had similar reactions, I have no doubt. So this is the case. In Singapore, all the cases are confidential. So the case names are only initials. This is CBG versus CBH. They're running out of initials. And it's a very interesting case. As we all know, emergency arbitration is becoming more of a thing. Emergency arbitration didn't exist 15 years ago. It came about by virtue of amendments to institutional arbitration rules, which basically said that either shortly before or once you begin an arbitration, you can get a special kind of arbitrator, maybe, called an emergency arbitrator. I said arbitrator maybe because I think it's a question like this person. What this emergency arbitrator can do and only can do, because her powers are limited, is in a very, very fast track decision. I mean, like 10 days, a couple of weeks, maybe a bit more. Decide whether or not to grant emergency, not just interim relief, but emergency interim relief that is so urgent it can't wait the constitution of a full tribunal, which, as we know may take, especially if one party being recalcitrant once or at least weeks. So you can go to this emergency arbitrator. She can conduct a hearing online these days. She almost always does. And she can make an award or a decision or an order within a very short period of time, which then can either freeze the status quo or return things to the previous status quo. She can't decide the party's dispute. She can only issue interim measures when indeed urgent emergency interim measures. I said tongue in cheek, perhaps. Is she an arbitrator? Maybe she's not even an arbitrator. One of the definitions of an arbitrator is that you finally resolve the party's dispute. She's surely not doing that. All she's allowed to do is emergency stuff until the real tribunal full of real arbitrators come along. On the other hand, she does finally decide this application of emergency relief. And because of that, the Singapore court, Singapore trial, sure enough, the appeals, said that it would recognize an emergency award made by an emergency arbitrator in the United States, granting emergency relief, subject to the same limitations that would apply to any foreign arbitral award, meaning you need to show that the award debtor or can resist recognition by showing no opposition occurred, violation of the policy, no arbitration, that sort of thing. And in this particular case, although the Singapore court said that it would in principle recognize foreign arbitral awards, it also concluded that the emergency arbitrator hadn't afforded the parties an opportunity to swipe right. Emergency arbitrator really ought not to say must not defendants be regarded as an arbitrator. She has the authority to finally resolve the dispute, and her decision is finally binding with respect to that thing. Other U.S. courts, right? For them, have also said that grants of interim relief are awards that can be recognized. Also, swipe right in that you can resist recognition of the emergency award based on the same grounds that exist in the convention for other awards. Indeed, I would suggest, because life as an emergency arbitrator is especially hard, you got to be particularly careful about procedural violations. Parties can be more easily denied the opportunity to be heard. And to be honest, emergency arbitrators can more easily go awry, misunderstand the case because they haven't had as long to think about it. Therefore, there ought to be careful scrutiny of the reports. That might be more likely than the case. Swipe right to those propositions. Oh dear. Swipe left. Left. You probably heard about this case. Nigeria, Federal Republic of Nigeria versus IUP. A distinguished tribunal of retired English judges made an $11 million award against Nigeria proceedings, which were more or less the time ran to challenge the award under the English Arbitration Act, but something that was challenged anyway. This is a fraud. The alleged basis for fraud, which the English High Court, the trial court, they upheld, was twofold. Firstly, that there had been perjured testimony in the arbitration, specifically and only a witness statement by a since deceased principal by UP, stating that his company had done certain things, and saying done a whole lot of preparatory work where subsequently in the English High Court proceedings appeared that in fact they didn't have the things that they had, he said they had, and they had done preparatory work that he said they had. So that was perjury. The second thing was that the two barristers, not American, barristers, in the arbitration and contingent fee agreements, which would have given one of them like $2 million. Basically, successfully resolved, and the other one. This is all based on what I'm saying. It's based on what the English court said. Those were the allegations that the court found. Right, and that those two barristers had authorized payments to Nigerian government officials during the course of arbitration to obtain privileged material from Nigerian government about the arbitration that had affected the prosecution of the arbitration. Based on those two findings, perjured testimony without criminal bribery of government officials by the court set aside the award on the basis of fraud. He had offered some extrajudicial observations, including that the arbitral tribunal hadn't done what it should have done to protect the public rights, number one, and that we ought to rethink international arbitration involving state-owned entities in light of this decision. So, I think we've got a variety of swipe choices. Choice number one, conduct of counsel. It is what the court found. Swipe left, probably hard. That sort of conduct, whether it's arbitration or judicial proceedings, whatever we can say. Sanctions. It's a little bit like what Qatar did in its ICJ proceedings against Bahrain, which is perjury, forgery, is unacceptable. Vacate the award, probably swipe. You might be thinking, probably swipe right. Of course, you should vacate the award. Yeah, I think you should vacate the award, but a couple of things. The English court never described what any of the privileged communications that were obtained from the government. Perhaps the simple fact that some sort of privileged communications were obtained is sufficient to set aside the award where those communications were obtained. Perhaps that would not be a crazy. Ordinarily, though, you need to show that a procedural irregularity has some impact on it. So if those communications, in fact, didn't have any substance, didn't have any impact on the arbitration, very important we should set aside. Note that this was basically an office. You chose not this award. Participate in the arbitration. The perjury, ordinarily, perjury testimony ought to be pretty strong basis for setting aside the award, but not just perjury testimony about anything. If somebody says, my expert report says I participated in 700 arbitrations. So it turns out it's 698, 702. Is that a sufficient basis? If I really said that, would that be sufficient basis to set aside the award? No. I think you would need to look at what the perjury testimony was, and how it affected the tribunal's decision. It was so shocked, so distressed by both the magnitude of the award and the gravity of the misconduct. What the barristers did was
Can I?
I think that was my question.
I'm not an expert on Spanish law. We may have a dissenting opinion, but we may have somebody who wants to swipe left or right.
Can I ask whether it should be?
Yeah, the fact is that the arbitrator was appointed by the court. So it was really the same court that after the arbitration, the award was issued, and due to a number of facts, that probably are missing in that, decide to reject the authority to the arbitrator. So I think that I will not be that string on your decision because there are a number of facts that have not been reflected in the decision.
Can you help us on the facts that the court who appointed him subsequently withdrew the appointment? What was the reason that they withdrew the appointment? I think I know, but I'm sure you know that.
Well, there was a problem, but the party defending Malaysia is the lawyers are Uriah Menendez. In one version of the facts, and I'm not an expert on the facts because there are really two opposite views. Uriah Menendez missed the deadline to appeal, and actually Malaysia did not appeal in all the procedures. But in a given moment, after they elapsed the opportunity to appeal, they appealed. And in that moment, due to diplomatic pressures of Malaysia, is when the Spanish Supreme Court, the Spanish Superior Court of Justice, then reject the authority to the arbitrator. So that's the contradictory facts in this case.
So maybe I swiped right too quickly. We can certainly come back and discuss that in greater detail. I do think when an arbitrator has his or her authority to revoke that court of arbitration, a reaction of moving the seat to somewhere else and continuing the arbitration, particularly if you're a national in that state, one that most gentle way, it requires a whole lot of courage. Put in a somewhat more negative way is very likely to expose you to some sort of. We can come back and talk about that later. I want to get done, so all the people get done. On this one, swipe left. It's a little bit ancient history, but ZF Automotive versus Luxshare, Section 1782. Section 1782 of Title 48 allows for an interested party or a tribunal in cases where there is a foreign or national tribunal to seek the assistance by way of disclosure, discovery from the U.S. Supreme Court. U.S. Supreme Court decided that an arbitral tribunal is a national tribunal. One would have thought that a dictionary would have been of assistance to them. Had the dictionary not been satisfactory, they would have treatise, which was the right answer. The right answer being arbitral tribunals are the most obvious example of international tribunals that ever existed. Hence, the Supreme Court's decision is a strong swipe left. It is tragic for ancient history because Section 1782 is no longer available in commercial arbitrations, and in all likelihood not available either in either investment arbitrations under bilateral investment treaties or other than or indeed under arbitration itself. I think there's a little bit of potential daylight on that last question. So it's a tribunal issue of international tribunal. The court in CF Automotive with emphasis on the fact that a private arbitral tribunal, elemental tribunal, perhaps tribunal has some courts that Section 17 are available. This one hardly deserved the slide. I went back and forth on it, but I fell in love with the name Sundance, so I kept it. Morgan versus Sundance, especially for here in Miami. The question, in some sense, isn't that important. As you probably remember, this is a bit old history. Most U.S. courts of appeals have held that in order to waive your rights under an arbitration agreement, you need not just show, the other party need not just show that you've acted consistently, badly, consistently with those rights, but also prejudice as a consequence. The Supreme Court said that the FAA doesn't permit so-called arbitration-specific procedural rules, and that waiver doesn't require a showing of prejudice. It only requires a showing of actions inconsistent with the rights. It essentially permitted the right to arbitrate more readily waived than most courts of appeals. Swipe left, because it's good to have arbitration-specific rules, because arbitration is a very specific type of dispute resolution mechanism that we ought to pay attention to. Interested, but ought to pay attention to Congress's intentions in adopting the FAA. So swipe left, you shouldn't have to show prejudice. You should have to show prejudice. We're really close to the end. This is in the category of is winter coming? Is coming to Ukraine, at least arguably. A couple reasons. We don't go into all of those, but I'm confident that summer will come in due course for those reasons. This particular decision, though, is a bad one. The Ukrainian court set aside the award made in Ukraine on the basis that the dispute concerned medical equipment, and that all disputes concerning medical equipment were subject to the exclusive jurisdiction of the Ukrainian courts. Swipe left. If countries are allowed to take rights out of their commitment under the New York Convention to recognize agreements to arbitrate by saying that preferred subject matters are subject to the jurisdiction of local courts. The New York Convention and the arbitral process will end up looking like Swiss cheese. Nothing Swiss, but I prefer a solid block of New York Convention authority. This, in my view, is both bad policy, but also consistent with the New York Convention requirement that you recognize arbitral agreements to arbitrate. And with that, I think I've pretty much exhausted all. There are a few other things to talk about, but I can sense an audience's tolerance for more footnotes, and I know I've reached the end. Just one final thing to leave you with, it's an intellectual teaser. Suppose that an arbitral tribunal decides that there's no arbitration. The respondent in the arbitration sending its jurisdictional objections to the tribunal, which decides that the exercise of its competence free. No arbitration, effectively saying we're not arbitrators, we're just law professors or some other lesser species. Does the arbitral tribunal have the authority then to award costs to the successful respondent against the unsuccessful claimant? Of course they can't. They're not arbitrators. How can they award anything? Swipe left. That's not right. English Law Commission started out with, we can end up with, they want to amend the Arbitration Act to provide explicitly that the tribunal can make an award of costs in the event of what's called a jurisdictional movement. Do you need to amend the FAA or the Australian law or some other national arbitration legislation to give this authority to the arbitral tribunal? No. Why not? It's already got the authority. How can it have the authority if it decides there's no arbitration? Did you just say that they're not even arbitrators then? They are arbitrators with respect to the question of whether or not they have jurisdiction. And the claimant who has exactly invoked their authority has submitted itself, therefore, both to their decision on jurisdiction, but also the resulting consequences, including cost consequences. Swipe right for that answer. Swipe right for a tremendous audience and a very annual lecture. There's my end goal.
Thank you, Professor Warren, for a wonderful lecture. Thank you all for coming on stage for this event. Courtesy of Wayne Peace, we have a reception set over there with some drinks and food, and I invite you all to join us.
Thank you.
As your book.
I'm happy Sorry, I'll pull out these things.